The Director of National Intelligence confirmed that in addition to phone data, the federal government has been secretly collecting information on foreigners overseas for nearly 6 years from the nation's largest internet companies in search of national security threats. The disclosures came after a day of controversy about the collection of phone data. The National Security Agency, operating under secret court orders to thwart suspected terror plots, was authorized to track calls to and from phone numbers of millions of Americans, even those not tied to terror investigations, and track the duration of the calls. But the Obama administration insists it did not listen to the conversations or record the names of the callers. The program was approved by the Secret Foreign Intelligence Surveillance Court, located inside the federal courthouse in Washington. Counterterrorism experts told us this surveillance is ongoing and involves most major telephone companies, not just Verizon. Some lawmakers, such as Wisconsin Republican James Sensenbrenner, who wrote many of the legal rules covering such data collection, criticized the scope of this surveillance.
It's a huge overreach, and it is abuse of the powers that have been given to the government.
But a majority of Republicans and Democrats did not object. Senate Majority Leader Harry Reid.
Right now, I think everyone should just calm down and understand this isn't anything that is brand new. It's been going on for some 7 years.
Attorney General Eric Holder, a key player in decisions about seeking phone tracking authority, won praise from South Carolina Republican Lindsey Graham.
I'm a Verizon customer. It doesn't bother me one bit for the National Security Administration to have my phone number, because what they're trying to do is find out what terrorist groups we know about and individuals and who the hell are calling.
James Clapper, the Director of National Intelligence, is attempting to set the record straight about how the government collects data from people's phone and internet use. Clapper says he is declassifying part of the program in order to allow the American people to better understand it. Our guests to talk about this are Jim Harper, the Director of Information Policy Studies at the Cato Institute, who is in Washington, and also joining us via Skype is Jack Clunan from Caldwell, New Jersey. Jack is a 25-year veteran of the FBI and the head of the global security company Red 24. Good morning to both of you. Thank you so much for joining us. Jack, I want to start with you. What we do know is that the NSA did not collect actual information about content of phone calls, content of emails. What exactly were they looking for? What was the purpose of this?
Well, the term of art, Debbie, is called metadata. It's the phone number, duration of the call, number called, that sort of thing. It's not listening to the actual conversations. And really what this is designed to do in the aggregate is to give us a leg up, if you will, on trying to detect plots that are either underway, probably possible discussion. And what it is, it's a tacit admission on behalf of the government, in my view, is that, we're not metaphysically perfect. We don't get things right all the time. And this is why we cast such a broad net. We're trying to prevent another act of terrorism happening on our shores.
Indeed, and in fact, one of the officials said that this leak to the media was reprehensible, that it hampered our abilities to be able to counter terrorism. I suspect that this might spark another investigation similar to the one that the DOJ launched into the AP, looking for a leak there. Won't this just make this pot more muddy?
Well, it will, and I've been an affiant. In other words, I've had to provide probable cause to the FISA court over the years to get a foreign intelligence wiretap, which was focused on foreign. And I want to emphasize that to your listeners. This was based on foreign. What has happened is that since 9/11, and perhaps our other guests will comment on it as well, the bar has been lowered quite a bit. And so I am a bit concerned about the scope of this. I understand why the government is trying to do this. But let me just make 2 quick points. Number one, the Intelligence Committee and House Select Committee in the person of Mike Rogers has said we have stopped an attack in the United States based on this program. I suggest to you that the plot that he's referring to was Mr. Zazi, who was going to blow up subway stations in New York. So we have no problem with that. The second thing that concerns me is if this program was in existence for 6, 7 years and it's authorized every 90 days, wouldn't this program have conceivably picked up some information related to the Boston bombers, to Tamerlan and Zakaya? They didn't. And that concerns me. So how effective is the program? What potential is there for abuse? And mistakes that will be made. And make no bones about it, mistakes will be made.
Indeed. Jim, I want to bring you into this conversation. And as Jack already alluded to, the fact is that this program had to be approved by Congress, as I understand it, every 90 days. The last time was back in December during that lull between Christmas and the beginning of the year. So this is not something that was any surprise to our Congress, just a surprise to us. Why is this so shocking?
Well, it's not a surprise to Congress. In fact, it's not a surprise to people who are watching what the law allows. What's surprising is that breadth of information that Jack was speaking about. And I agree with many of his questions. In a society like ours, a free society, we shouldn't have this many questions. I wonder about the creation of a secret court and secret rulings. Evidently, according to Senators Wyden and Udall, there are secret interpretations of law. That's actually a challenge to the rule of law. We're supposed to be able to understand what the law is so that we can properly oversee the government, and that system is failing here. So I have a lot of questions too. I think it's very concerning that all the phone numbers, called by all people in the United States, are now coming to rest in the National Security Agency's databases. If you make a telephone call today, the data about it will come to rest in a database. And metadata is a term that sounds technical, but it reflects who you called, how long you spoke for. Did you call your psychiatrist? Do you have a paramour? Do you talk to a teenage son or daughter at strange hours of the day or night? We have a government where so many people, of course, are working hard for the betterment of our society, but we also have the very recent experience of the IRS Tax Exempt Organizations Bureau, which twisted its role into becoming a political defender of the status quo. How do we know that the National Security Agency doesn't have a bureau like this or staff like this who will abuse access to that information? They promise, and I take those promises as genuine, but we can't know unless we get proper oversight. So the secrecy veil has to come off.
You bring up a very good point. Of course, we are all protected by a Fourth Amendment right against the undue search and seizure. Of course, the Patriot Act allows exceptions to that. In your mind, did the government abuse the Patriot Act with this?
Well, let's be clear. The Fourth Amendment was not amended by the Patriot Act. The Fourth Amendment ban on unreasonable searches and seizures remains in place, and the Fourth Amendment's bar on general warrants. I think what we have here is a general warrant to collect all phone calling information and even more information we learned last night in the PRISM program from web surfing and email and all kinds of things. A general warrant, all Americans' information. This would have caused the framers to turn over in their graves. It's exactly what they tried to bar with the Fourth Amendment. The Congress allowed this kind of thing to happen, but with that Patriot Act power and with the creation of this secret FISA court, the Foreign Intelligence Surveillance Court, that's a broken system, and it's a system that doesn't reflect our values as Americans. It doesn't obviously uphold the Fourth Amendment, as we see a clear violation of the bar on general warrants in this case, now that the document's been leaked.
Jack, I'm just curious. Of course, this involved all the major carriers, not just Verizon, including Apple and Google. Could they have refused to participate in this, or had they had no choice?
Well, they're acknowledging that they're not participating in this, which I think is rather ironic, because what this has allowed is the government direct access to their servers, which is unprecedented. I think to the point our other guest was making, if I was to go into a judge today in a criminal setting and I wanted to get a wiretap, I can assure you that based on the information that we're hearing about the PRISM program, no judge that I know would ever sign off on that warrant to get a criminal Title III warrant. They really wouldn't. This broad-based approach under the FISA court, I don't want everybody to think that this is just a rubber stamp, because that seems to be what everybody wants to criticize. There are a very serious review process. I do think, though, that this idea of collecting the metadata, getting access to emails, and that sort of thing should give us all pause. And again, I want to go back to why we're doing this. What's the efficacy of this program? I think we need to shine some sunlight on this. We need to lift the veil a little bit. We, the public, need to know exactly what the legal underpinnings are for this program, how effective it's been, and if the government can point to issues where it's been successful, then let's do it. Let's not just get us all wrapped up in the language. I mean, I used to have a pretty good understanding of what the FISA court was about, what an affidavit to the FISA court expected. And I have to tell you, from looking at this stuff, I am totally confused, absolutely confused. And I was a practitioner. I knew what I was supposed to do. But these amendments, voted on and approved by Congress, have left me scratching my head.
I understand that, and that speaks volumes. Jim, I want to end with you, and I just have a few seconds. I want to pose the question that you posed in an article that was published yesterday, and that is, what should the public do about this?
Well, it's up to the public to oversee their Congress. I don't think Congress is given sufficient oversight to this program, to the secret FISA court. It's caused this general warrant issue. Now we need to ask our members of Congress, what have you done about this? How are you doing oversight? They shouldn't give away their authority to the leaders of the House Intelligence Committees, or the House Intelligence or Senate Intelligence Committees. Each and every member of Congress should be looking into this for him or herself, asking why all of their constituents' phone records are being maintained in the National Security Agency's databases.
Jim Harper and Jack Clunan, gentlemen, thank you very much.
Thank you.